thank you all for being here today. I really appreciate folks' interest in this very important topic, regulating tobacco marketing in New York State, constitutional basics that you should know. My name is Tom Pryor. I'm a lead senior staff attorney here at the Public Health Law Center. Very pleased and honored to be joined by Kevin, who's a professor and a litigator in New York State, to talk about these issues. A little bit more about the Public Health Law Center. We're located at the Mitchell-Hamlin School of Law in St. Paul, Minnesota. We acknowledge that we are on the indigenous homelands of the Dakota people, also known as the Sioux Nation, and that 4 federally recognized Dakota tribal nations remain in this area. We appreciate their ongoing stewardship, spiritual connections, and the life waves they've developed in these homelands upon which the law school sits. The Public Health Law Center offers free legal technical assistance to all communities, public health advocates, and other partners. We also publish widely on commercial tobacco control policy and offer trainings and webinars like this one. We do not, however, offer direct legal representation, nor do we lobby. At the Public Health Law Center, we prize equity above equality. Equity is about giving people what they need, which includes understanding barriers, circumstances, and conditions. In an equitable society, something like your race, gender, or sexuality should not be predictive of your health or happiness. Now, when we talk about public health at the center, we take a broad view of it and talk about the social and political determinants of health, the network of policies and factors from housing to education to the criminal justice system that impacts people's health and happiness. And one final note before I begin, when I talk about tobacco products today, I'm going to be speaking about them in terms of industrial scale commercial tobacco production, not traditional tobacco, which is used religiously, medicinally, and ceremoniously in many different cultures and tribal nations. Now to the content. My focus today will be on how and to what extent the government can restrict advertising consistent with the US Constitution. Kevin then will discuss the same sort of issues, but with regard specifically to New York State's Constitution and several laws and lawsuits that have happened in New York State about these same topics. And we know that tobacco marketing is powerful and often very problematic, whether it's offering discounted or low-cost products or marketing designed to appeal to youth or placing tobacco products next to candy. The industry engages in a lot of practices designed to attract new users, especially young users, and to grow their customer base. And so it stands to reason that many public health professionals would attempt to limit these problematic practices through things like marketing bans and regulations. But unlike straight up sales bans, marketing bans encounter a unique constitutional barrier, the First Amendment, which protects the freedom of speech. As a preliminary matter, it's important to note that the First Amendment broadly protects speech, which includes things like verbal speech, but also written speech and expressive conduct. The First Amendment's protections are expansive, covering everything from speaking at political rallies or wearing protest armbands to discussing the weather or blogging about TV shows. It also protects commercial speech, or expression related solely to economic interests of the speaker and its audience. Typically, speech proposing an economic transaction, such as advertising, soliciting, or marketing communications. But while covered by the First Amendment, we'll see that commercial speech does not receive the same degree of protection as core speech. And that's because it takes place in an area in which there's traditionally been more government regulation, and potentially because it's seen as being less essential than core speech. It's also important to note that many states have within their own state constitutions protections of the freedom of speech and expression. And oftentimes, and this is certainly the case with New York's Constitution, these state constitutional provisions are interpreted as being coextensive with federal protections, so that if a law violates the First Amendment of the federal Constitution, it will also violate the state protection of free speech as well, and vice versa for laws that don't violate the First Amendment. And that's why Kevin's going to be here to discuss some of the unique New York rules or wrinkles that you should be aware of. So I'm going to begin by talking about doctrines and rules at courts, because we know that judges make decisions based on facts and the law. And by law here, I mean statutes, regulations, but also rules or precedents laid out by previous courts. Generally speaking, if a higher court has already resolved a similar issue, a judge should try to adopt the same reasoning and come to a similar result. So if the US Supreme Court tackled a case that's a lot like a one that's in the Southern District of New York, for example, that New York District Court should try to adopt a similar reasoning and come to a similar outcome as the Supreme Court. And this comes from an important concept in our judicial system, the doctrine of stare decisis, which means to stand by things decided. This approach to resolving cases creates predictability in the law, and it also constrains judges. They can't just decide whatever they want. Instead, they should act consistent with past decisions. But how do you figure out what cases are precedential for the ones you're reviewing, and how do you adhere to that precedent? Generally speaking, judges try to make it clear in their written opinions how and why they're deciding cases as they are. And in doing so, they try to explain the rule they're using and the sorts of cases that the rule should be used for in the future. So a court won't just search for cases that have the same or similar facts as their own and then just blindly decide the case in the same way. The judge will instead look for rules or doctrines that explain how they're supposed to weigh facts and what analytical steps they should take to reach a decision. This is all pretty abstract, so let's try an example. Let's say you're a judge and you're reviewing a case in which the plaintiff slipped and fell on the steps outside of a bookstore and then sues the store owner over their injuries. So you can look for cases that have the same facts, someone slipping and falling in front of a bookstore. And if you find one, you can just decide your case the same way. So maybe the plaintiff won in that previous case, and so you could just copy and paste the same outcome here. But in the written opinion of the previous case, the judge probably explained how they reached that decision. Perhaps they explained, for example, that the shop owner is liable only if they had control over the steps, if they negligently maintained them, and if their negligence was the but-for and proximate cause for the plaintiff's injuries. That phrase would basically be the rule or doctrine for tort liability in these sorts of situations, and you could use it to weigh the facts in your case. So maybe the shopkeeper owned the steps and even negligently maintained them. Perhaps they were crumbling a bit. But perhaps the plaintiff slipped on a banana peel that a previous patron had just dropped on the steps. So it wasn't the shopkeeper's fault because their negligence was not the proximate cause of the injury. The banana peel was. A rule or doctrine, then, is a way for judges to know what facts are relevant and how to weigh them as they reach a decision. It's kind of like an algorithm, and it's helpful to understand these doctrines because if you know them, you can predict how a court might treat a hypothetical case in the future. You just plug in the facts and follow the analysis as previous courts have done, and you'll have a general idea or prediction of what might happen. The main point I want to get across during my portion of today's presentation is that a court reviewing a law that regulates speech will use different tests or frameworks to analyze that law, and those tests can be more or less difficult to pass. In the constitutional realm, the most common tests or doctrines are different levels of judicial scrutiny. This is basically the idea that, dependent upon the context, a reviewing court might be more or less skeptical that a challenged law is constitutional. Sometimes they'll apply a very rigorous level of scrutiny, and so the government would have to clear a high hurdle in order to prove that their law is constitutional. Other times, it will be a low hurdle, and the government will have an easy time defending its law from a constitutional challenge. And these levels of scrutiny are used throughout constitutional law and in the First Amendment context as well. So here are the three levels of scrutiny that courts apply to cases in which a government law is challenged based on its constitutionality. And you can think of these levels of scrutiny as existing along a continuum, with the most rigorous being strict scrutiny. If a law triggers strict scrutiny, the government will bear the burden of proving that its actual purpose in passing the law was compelling and that it chose the least restrictive means of achieving that purpose. Strict scrutiny is often called strict in theory, fatal in fact, because it's so difficult to meet those requirements. On the other end of the spectrum is rational basis review, which is a very low hurdle to clear. If a law triggers rational basis review, it must only be rationally related to a legitimate goal, and really any conceivable goal, even one that's cooked up by lawyers after the fact, is enough. Intermediate scrutiny sits somewhere in between those two, and that the government's actual purpose must be important, and the means must be substantially related to achieving that purpose. In practice, there's probably a lot of wiggle room in how strict or lenient a court can be within this intermediate zone. So if a law gets strict scrutiny, you can bet that it will probably be struck down. And if it gets rational basis, the smart money is that it will be upheld. But with intermediate scrutiny, it's much more difficult to tell. And that's important because most First Amendment specific tests and doctrines fall in between strict scrutiny and rational basis, and it can therefore be difficult to predict how a court will come out on any particular issue. And these basic levels of scrutiny are used in multiple areas of constitutional law, and as I mentioned, you can think of them as sitting along a continuum. You can also visualize how specific tests or frameworks for assessing First Amendment questions sit along the same continuum. Let's begin with what's known as the Central Hudson test, named after the case from which it originates. And as you can see, this is a fairly exacting test, although not as much as strict scrutiny. This test would apply to any situation in which you're restricting commercial speech, like a law banning retailers from displaying tobacco ads in their windows. It's essentially the default test for commercial speech cases. Now, normally, a law curtailing someone's ability to post a sign in their property would probably get strict scrutiny, but as I mentioned, commercial speech is not protected to the same level as other forms of speech, so it gets Central Hudson scrutiny instead. And while the Central Hudson test is exacting, it's not quite as demanding as strict scrutiny is. I should note here, too, that Justice Thomas has challenged the premise that commercial speech should receive less protection than other forms of speech, and a variety of his concurring and dissenting opinions at the Supreme Court. As far as he's concerned, if a law targets the content of the speech or is directed at particular speakers, it should get strict scrutiny, even if it is a commercial speech regulation. And I mention that because even though it would be a fairly radical departure from settled constitutional law, many of Justice Thomas's constitutional theories have become the law of the land eventually. And so I'll come back to this at the end while we talk about drafting tips. If a law triggers Central Hudson scrutiny, the court will ask first whether the law restricts protected speech. So an example of unprotected speech might be something like an advertisement offering to sell an illegal product. And typically that sort of speech is usually covered by things like criminal attempt and solicitation laws. And if that's what's at issue here, you don't really need to go through the rest of the Central Hudson analysis. It's perfectly permissible to restrict that unprotected speech. But if the law does restrict protected speech, the court will next ask if the law is justified by a substantial government interest, if the law directly advances the governmental interest, and if there's a reasonable fit between the goal and the means chosen to accomplish that goal. So you can see elements of intermediate and strict scrutiny here. The interest need only be substantial, not compelling, but the means should directly advance the government interests. In practice, these last two prongs are often most difficult to satisfy. Most public health laws aimed at restricting tobacco advertising are justified by a substantial government interest, protecting public health. What's more difficult is proving that the law restricting speech directly advances that goal and that there are not other means of achieving it that have a better fit. The Central Hudson is more of an art than a science, and sometimes when tackling these last two questions, a court will apply an analysis that perhaps looks more like strict scrutiny than anything else. So if, for example, a jurisdiction wanted to eliminate tobacco advertising within a certain proximity of schools with the goal of reducing youth rates, the court might require a great deal of evidence to prove that the restriction will achieve that purpose and that other means that intrude upon speech interests less would not be preferable. The next form of scrutiny I want to talk about is O'Brien-Ward scrutiny, which I've named after two famous Supreme Court cases discussing this type of analysis. This is a framework a court will use when a law restricts behavior or conduct with only an incidental or indirect effect on expression. So from the O'Brien case, a Vietnam-era law making it illegal to damage draft cards can be used to restrict expressive conduct if it's employed to punish an activist who burns a draft card in protest. But the law would probably be upheld under this level of scrutiny to the extent it's not designed to target that expressive behavior. In the tobacco context, this framework would be used for laws that restrict where products can be placed, most obviously laws that eliminate self-service displays of tobacco products. This is definitely an expressive element to product placement. That's why marketers think a lot about what goes in end caps or by the cash register, for example. But you can still regulate where products are placed if the intent is to prevent youth from getting easy access to the tobacco products. So yes, the law might incidentally burden the expressive element of product placement, but that's not the goal of the law. A court will ask the following questions for this form of scrutiny. Does the regulation further an important or substantial government interest? Is the governmental interest unrelated to the suppression of free expression? And would the interest be achieved less effectively without the regulation? So you can see how this is a less rigorous form of scrutiny, more proximate to intermediate scrutiny. The government interest need only be substantial, not significant, and certainly not compelling. And the policy doesn't have to be the least restrictive means. Instead, if alternatives would be less effective, that's enough to prove that the law has a sufficient fit between the means and the ends. Where jurisdictions might get tripped up, however, is with the intent element. For example, some jurisdictions have considered enacting laws that would ban placing tobacco products near youth-oriented products like toys or candy. That might not pass O'Brien Ward scrutiny because it looks more like the law is targeting the expressive element of the conduct, the association between tobacco products and kids' products, and not simply addressing access issues. It might still be a constitutional law, but it would probably just be reviewed under the more demanding central Hudson framework instead of under O'Brien Ward. One example that helps explain this comes from the Lorillard v. Riley case at the Supreme Court, where the Supreme Court upheld a Massachusetts law prohibiting the use of self-service displays and requirements that tobacco products be placed out of the reach of all consumers and in locations that are only accessible to salespersons. The court recognized that there could, in fact, be a communicative component to product placement, and so the law did implicate the First Amendment, but they upheld the regulation because it was directed at the conduct and preventing minors from accessing tobacco products without first getting proper age verification. And here's where you can see how important it is that the regulation not be directed at the communicative component of the behavior, because the court mused that presumably a retailer could display empty boxes of cigarettes wherever they wanted, because it's not about the box and its labeling, it's about the product and whether kids can access it. The most lenient form of scrutiny I'll talk about today is called Zouderer scrutiny, also named from the case from which it derives. Now, this would be used when the government requires a speaker to carry an extra disclaimer, disclosure, or warning. And such laws don't limit speech, they actually require more of it. And for that reason, courts are often more willing to permit mandatory disclosure laws than laws that ban or restrict speech altogether. A court applying Zouderer scrutiny will ask if the disclosure requirement is reasonably related to a legitimate government interest, if it's purely factual, accurate, or uncontroversial, or if it's unjustified or unduly burdensome. Now, some courts have argued that preventing deception is the only government interest that qualifies for this lower level of scrutiny. To them, it's not enough to simply provide useful or accurate information. The disclosure requirement should correct some inaccuracy or common misunderstanding about the product or service. But many circuits, including the Second Circuit, which includes New York State, take a more expansive view of this, ruling that providing important public health information can also qualify as a legitimate government interest justifying the disclosure. The disclosure must also be purely factual and uncontroversial, and those 2 points together explain why Zouderer is a lower level of scrutiny than the other tests. Speakers don't have as much of a First Amendment interest in omitting accurate disclosures that provide important information to the public. But that second prong is also an easy stumbling block for governments, because if a compelled disclosure is too forceful, for example, it might fail because it's no longer uncontroversial. And those were the issues at play in a recent decision by the Fifth Circuit in R.J. Reynolds v. FDA. In that case, R.J. Reynolds had sued over the FDA's graphic warning labels requirement, arguing that they were unduly burdensome and that they violated their free speech rights. The district court sided with the industry, but the FDA appealed and actually won at the Fifth Circuit Court of Appeals, which ruled that the graphic warning labels satisfied Zouderer scrutiny. Now, I should note that R.J. Reynolds has petitioned the Supreme Court, and the Supreme Court might take up this case and reverse the Fifth Circuit's ruling. Other circuits might also disagree with the Fifth Circuit, even as the Supreme Court rejects the petition. But the Fifth Circuit does have a reputation as being one of the more conservative circuits in the nation, and so there's cautious optimism that this will indeed be the prevailing rule, either because the FDA will win at the Supreme Court or because other circuits will adopt the Fifth Circuit's analysis. I'll summarize this opinion at a high level because it's an important one, and generally it basically tackled the major elements of the Zouderer test. Now remember, if the warnings don't qualify for Zouderer scrutiny, the court would probably default to central Hudson scrutiny in analyzing them, which is more exacting standard, and there'd be very good reason to suppose that it would fail that test. The first question the court tackled was whether the warnings were purely factual and uncontroversial. So industry's argument here is that the warnings exaggerated the health risks of smoking and that the images could be misinterpreted by consumers, and that in any event, they couldn't be considered purely factual and certainly not uncontroversial, given that they were likely to evoke strong emotional responses or even shock from users. The Fifth Circuit disagreed, however, and ruled that the warnings were purely factual and uncontroversial. The written statements were clinically accurate, as were the illustrations. And to be sure, those statements and illustrations might evoke an emotional response, but facts can do that. A statement or illustration does not become inaccurate or controversial simply because it's upsetting. The next question is whether the warnings advanced a legitimate government interest. And here, industry's argument was that the only interest that the government is allowed to pursue when it compels a disclosure is the goal of preventing deception of consumers. And again, the Fifth Circuit disagreed with industry and ruled that the information interests advanced by the warnings were legitimate and sufficient. So this portion of the opinion parses a lot of case precedent, but suffice to say, the Fifth Circuit recognized a growing consensus among the appellate courts that anti-deception interests are only one of many legitimate state interests that can justify a compelled disclosure, and here the interest of advancing public health was sufficient. Finally, the court tackled the question of whether the disclosures were unduly burdensome. And here again, industry argued that the size and emotionally laden content of the warnings impose an undue burden upon the industry, and they lost on that point as well. The court was unconcerned about the size of the warnings, noting that they only took up 50% of the package and that they have only minimal interest in refusing to carry accurate and useful warnings on their packages. So certainly the warnings could impose a burden, but that burden was not undue. So to summarize, the Fifth Circuit rejected the industry's challenge to the graphic warnings and ruled that under Zouderer, the warnings were justified and did not unduly burden industry's commercial speech rights. So governments can compel disclosures even through graphic disclosures, but they do run the risk if the disclosure is deemed inaccurate or controversial of having it struck down. Now, as I noted, a reviewing court could choose to review the regulation under the more exacting central Hudson test instead of Zouderer, and they could even review it under strict scrutiny. And that's because the court has typically taken a very dim view of compelled opinion statements. So for example, if a law required a disclosure saying something like smoking isn't cool, it would probably fall into the strict scrutiny territory and be struck down. Now, there's one final type of law that generally falls into this area of regulation that's worth considering, and that's government-funded public health campaigns that speak about the dangers of tobacco use. And that would be an example of government speech, and I placed it outside of the continuum of levels of scrutiny because typically that kind of speech doesn't trigger First Amendment analysis at all. The government can freely engage in public health communications, and for the most part, doing so doesn't infringe upon anyone's right to expression. So I covered a lot of ground here today, and I'm happy to follow up on any of this during the Q&A, but just to do a quick wrap up, in addition to the traditional levels of scrutiny you find in constitutional jurisprudence generally, you should know about Zouderer, O'Brien Ward, and Central Hudson tests and how they apply to different forms of regulation of expression. Now, I'll end by saying that the First Amendment's jurisprudence is complicated, and it's difficult to predict with confidence how a court will treat any particular law. So successful drafters think strategically. You can't know for certain which test a court will apply to your law, so strategic drafters plan for strict scrutiny even while they hope for rational basis. To that end, laws that have been successfully defended often include substantial legislative findings within the law itself or in the legislative record to help bolster the case that the law pursues an important or even compelling interest and that it's been carefully tailored to achieve that interest. And that last point is very important too. The Supreme Court's position is essentially that it would prefer governments restrict conduct and behavior and not speech. So a law that limits expression, even if it's just related to advertising, will probably receive more judicial scrutiny than one that just bans products altogether. A product ban might feel more burdensome and expansive, but if the goal is to reduce use, it might be a better fit from a First Amendment perspective than an advertising ban. And this is doubly important because virtually all areas of constitutional law have been in a state of flux over the last 8 years or so. So even though the jurisprudence over commercial speech has been relatively settled, there's no guarantee it won't undergo seismic shifts in the future. So even if you think you can satisfy something like the Central Hudson test, your law might eventually be challenged under strict scrutiny analysis instead. So if you take nothing else from this presentation, I hope is that you go forth and proceed with caution when crafting policies that target marketing and advertising, and that you consult your attorneys early and often. With that, here's our contact information at the center, and I'm going to kick things over to Kevin, who is going to tell us with a little bit more detail some of the challenges that have been made against regulations within New York, and hopefully through those war stories, so to speak, we get a better understanding of what this looks like in practice. So Kevin, over to you.
Thank you very much, Tom. I will get my slides up here, and I'll just state that I think Tom did the heavy lifting today, and I'm going to talk about some actual cases in New York that go through and used some of the tests that Tom described. So we'll get a better understanding of how they actually played out in some real world scenarios. So here's a quick outline or overview of the cases that I'm going to talk about. And I'll just point out that there's 6 of them here. Each one relates to a law, and 5 of them relate to lawsuits that addressed those laws. There was one case where there was not a lawsuit challenging it. That was the number 5 one on this list. I'll point out also that the first 2 dealt with restrictions on types of transactions where there was an argument that there was a First Amendment issue, but the court didn't find that the First Amendment came into play at all. The second 2 cases deal with warnings, government required warnings. And then the last 2 deal with restrictions on commercial speech. So as we go along, the lawsuits or the challenges become more difficult or more stringent progressively. So first off, I'm going to, I should point out, I have a little picture here of Mayor Bloomberg signing tobacco legislation. And just in case you weren't looking closely, I've got a red circle circling a guy who might look a little bit familiar now. That's me from back in 2013, I think. And Mayor Bloomberg was signing a law that was the subject of the first case I'm going to discuss. So this was NATO, not North American Treaty Organization, but National Association of Tobacco Outlets against New York City. So this 2013 law was designed to increase tobacco prices in several ways. All 4 of them are listed here. And I'm going to focus on a restriction on discounts and other ways of reducing the prices of tobacco products. That's what the tobacco, and out of all the different mechanisms that were outlined in the law, they sued alleging that that discount restriction was unconstitutional. Now, again, this is a law that didn't clearly, at least in my view, implicate speech. It implicated discounts, but the tobacco industry tried to argue that the law was interfering with speech. That was speech of the tobacco industry trying to tell its consumers that they were getting a bargain. Now, the way the court looked at this, it did not actually involve speech at all. It was a permissible regulation of a commercial transaction. And what it did, the tobacco industry tried to say that we were preventing a certain type of speech. And while there might be some appeal to that idea because we were preventing certain things like you can't say dollar off, but the reason you can't say dollar off is because you're not allowed to offer that type of actual transaction, not because the content of the speech should have been restricted on its own. It was the transaction that mattered. A second case that I'm going to speak about is a recent case, Eastchester Tobacco and Vape versus the town of Eastchester. This is a case that went to the Southern District of New York, which covers New York City and some surrounding counties. And the town passed a ban on the sale of electronic cigarettes. So again, as Tom discussed, this was a sales restriction. It did not deal with speech, but the retailers sued and argued that it was preempted by federal law and it was also a violation of the First Amendment. The court, however, dismissed the retailer's case and it held that the First Amendment was not implicated by the local law and further explained that a sales restriction does not address speech. It addresses the transaction and prohibits that type of transaction for a particular product. Moving on, this case goes back a little bit. It was decided in 2013, and it deals with point of sale warning signs. So the New York City Board of Health passed a rule. So this didn't come from the legislature. It came from a New York City agency. Uh, the authority of the agency was not critical to this case, though. It passed a rule requiring warning signs at any retailer that sold tobacco products. And there were two different types of signs. The retailer would have the option of putting a small sign next to the cash register or a larger sign alongside where the products were displayed. New York City lost this lawsuit. There was a First Amendment issue that was argued in the case, but the case was not decided on First Amendment grounds. It was decided on federal preemption. The court held that federal law preempted a state, or in this case, a city rule that could have required these types of warning signs. Now, federal law, there's a federal statute that authorizes warnings on the packs of cigarettes, and that law contains a preemption clause that essentially says that the business of issuing warning signs related to cigarettes is a federal is part of a federal sphere of influence, and as a result, cities could not pass a rule requiring a warning sign that related to or infringed upon the advertising of cigarettes. So it didn't get to the First Amendment issue, but it raises an interesting number of questions. If the court had gotten to the First Amendment issue, what would have been the proper level of scrutiny? And Tom, walked through a number of different types of scrutiny. Now, for the first question that might have come up is whether this was government speech. Now, as Tom noted, government speech is typically what people think of when we're talking about advertisements, like pro-health advertisements, like ads that you might see on TV that are funded by like a health department or the CDC or the FDA that highlight the health risks related to smoking and promote cessation. And those types of that type of speech is generally considered government speech, and it's not scrutinized as a restriction on First Amendment activity. It's usually subject to rational basis review, so it's a pretty low level of review that typically would survive scrutiny. And in New York City, put its little logo in the upper corner. These three pictures are the three different warning signs that could go up, that were required or would have been required to go up in retail stores. New York City put the little New York City logo in the upper left corner, kind of as a stretch attempt to see if a court might be receptive to the argument that this was government speech entitled to this pretty lenient level of scrutiny. I don't think a court would have purchased or would have bought that idea, and they probably would have gone with Zauderer level scrutiny, because this wasn't just government speaking. This was the government requiring this speech in a retail store that probably would have preferred not to have the signs up at all because they want to sell their product. So it probably would have been the Zauderer standard, which typically involves compelled commercial speech, which would have raised those key questions noted here that we've already heard about. Are the images and messages factually accurate? Are they controversial? And are they unduly burdensome? And for each one of those, so for like factually accurate, for example, New York City took pains to find images that were realistic, so that they could say that they were factually accurate. They were aligned with text warnings that were also carefully researched to make sure that they would be factually accurate and not controversial. And then the question of whether they are burdensome but not unduly burdensome is another question. It's kind of hard to predict how a court would decide that, especially when you're dealing with the question of how burdensome it might be to a retailer. Retailers, some are very large, some in New York City in particular are very small. So if they have to put up a large sign in a small store, they might have a credible argument that it's a heavy burden for them. In any event, I only raise these questions to help think through what might have happened. We don't know because the court did not decide, as I mentioned earlier, the constitutional issue. So moving on, moving outside the context of tobacco to a case called National Restaurant Association versus New York City Department of Health and Mental Hygiene. New York City's Department of Health required these icons, which is we call it a sodium warning icon, to be listed on menu items in certain restaurants. It's based on the idea that excessive salt consumption can raise a number of health risks like high blood pressure, risk of CVD, heart failure, kidney disease. And these warnings would help people recognize when certain items on menus contained high levels of sodium, and therefore it was a piece of information that could help consumers to make healthier choices and avoid products that had high levels of sodium. The New York City Board of Health has jurisdiction to regulate matters related to the public's health, the food supply, and stores known as food service establishments that have a license to sell ready-to-eat food. And the Board of Health's rule, it didn't apply to all places that were licensed, but to sell ready-made food, but it applied to places that were chains, and the chain was defined as having 15 or more locations. It defined items that required the sodium as places that had more than 2,300 milligrams of sodium, and that is the maximum level of recommended sodium per day. Now, you might wonder why I'm giving you all these details, but the details become important when you consider that this is going to be subject, this is compelled commercial speech, and the expected standard of review. And I was involved in helping to plan this rule, and we anticipated that we were likely to be subject to a lawsuit, and the most likely standard of review was probably the Zauderer standard of review. So we wanted to make sure that we had a factual basis for the warnings and that it was uncontroversial. And I'll just point out this picture here has a menu on the side, and you can see there's a number of items. There's 7 items here, and 4 of them have the little salt shaker warning next to them. So that's what it looked like in practice. Anyway, New York City won. The court found that Zauderer was indeed the right standard. They found that the concept, they were factually accurate and uncontroversial. It was not unreasonable or overly burdensome or arbitrary and capricious. There were a couple other issues that came up in the lawsuit. And the NRA, not that NRA, but the National Restaurant Association, focused on controversy. They tried to muddy the waters related to the health risks posed by excessive sodium consumption. They argued that the science was unclear and sodium was a nutrient. And while too much sodium might be a hazard, too little sodium could be a hazard as well. So why did I mention that we chose 2,300 milligrams of sodium? Well, think about it this way. You want to err on the side of having a high number here to avoid some of the controversy, because there might be more doubt that lower levels of sodium pose significant health risks. Also, 2,300 was a specifically government endorsed level, maximum level recommended for a whole day. So we were saying if this food item, a menu item, has more sodium than you should take in a whole day, it's definitely got to be more than you should take in a whole in one sitting, in one meal. So that was one way of trying to deal with the controversy issue. As I mentioned, New York City won this one. All right, moving on. Here's the law that I mentioned where there wasn't a lawsuit. So New York State passed a law that bans the public display of tobacco products and advertisements for tobacco and e-cigarettes. It covers retail stores, exterior windows, and doors, so long as they're within 1,500 feet of schools in all of New York State except New York City. And then in New York City, within 500 feet of schools. And the differentiation is based on the density of an urban area like New York City. It also harkens back to a case decided in 2001, Lorillard versus Riley, where Massachusetts passed a law that had an effect on restricting outdoor advertising within 1,000 feet of schools, but it didn't have any differentiation between urban and rural areas. So you might be asking, why did the tobacco industry not sue New York State when they passed this law? And we don't know for sure, but I can speculate about it, right? So the New York State law is not as restrictive as the laws passed by Massachusetts in Lorillard versus Riley, or a law passed by the town of Worcester, Massachusetts, a number of years later. In Lorillard, Massachusetts had banned tobacco ads within 1,000 feet of schools or playgrounds, and it didn't have this sensitivity to urban versus rural. So New York State's law did have the sensitivity to urban versus rural, so it gets a plus. It's not as broad as Lorillard versus Riley, and that gives it a little bit of a bonus point if it were heading into a lawsuit that the tobacco industry surely would have thought about. I'm not saying that's why they didn't do it, but that would have been a factor that they would have considered. In the Worcester case, Worcester had banned all outdoor tobacco ads and indoor ads that could be visible from the outside of the store. So, and it didn't have a limitation about being close to schools or playgrounds. It was just a town-wide ban on outdoor ads or indoor ads inside a store, but visible from outside a store. So that was even broader than the Massachusetts law that had already been struck down. So again, New York's law is not as aggressive as either of those two laws, and both of those laws were struck down. So those two things are, that key thing that it was less restrictive than these other two laws that were struck down might have or probably factored into the tobacco industry's thinking, but we don't know if there were other factors that contributed to their decision not to sue. Anyway, if they had sued, it probably would have been decided under Central Hudson, and New York would have had an argument that it made an effort to restrict less speech than Massachusetts did, and who knows if that would have made the difference in the Central Hudson analysis, assuming it would have been Central Hudson, which seems likely, but you never know. And finally, I'm going to talk about product display bans. Product display bans are based on the idea that the visibility of tobacco products is a form of advertising, and the visibility of the product spurs purchases, it normalizes the product, it makes young people more susceptible to purchasing tobacco products. And back in 2012, Haverstraw actually passed a product display ban. The tobacco industry sued, and shortly afterwards, Haverstraw, which is not a large town, looked at the landscape and they were like, whoa, we don't want to be sued by the tobacco industry and fight this in court. This is probably more than we expected or bargained for. So they actually rescinded the law. They're like, okay, never mind. We're not going to do it. New York City, around the same time, also introduced a product display law, but there was significant concern in the tobacco control community over whether this was a wise move and whether it was a significant risk of losing a lawsuit. And given some debate and uncertainty, city council never even put it up for a vote. So it wasn't voted upon and certainly did not become law. But what would have happened if it had? So I'm going to briefly walk through Central Hudson factors, some of the factors that we already talked about during Tom's presentation. First, is the speech legal? We're not talking about illegal speech. We're not talking about, putting a sign on your garage saying, "Hey, crystal meth for sale," right? That would be illegal speech. You're not allowed to speak that way. Is there a significant government interest? Sure. Restrictions that could reduce, even restrictions on speech that could reduce tobacco use, could serve a significant government interest. But the third and fourth prongs, as we discussed, are the tricky and difficult ones. The third one is, does it advance a government interest? So this is really a question of how strong is the evidence that it would work, that it would advance the government's interest of reducing tobacco use. And this, it may, at first blush, you might say, of course, there's evidence that this would work. But when you dig deeper and say, well, how good is the evidence and where does the evidence come from? And what happens when the tobacco industry attacks that evidence? How well does it stand up to scrutiny? It becomes not as clear debate. And I'll get to this a little bit more in my next slide. And then the fourth part of the test is, okay, sure, there has to be evidence that it works, but does it go too far? You can't go too far. Does it restrict more speech than necessary to achieve the government's aim? And could something else that doesn't restrict speech accomplish the same goal without being a First Amendment problem? So that's the third and fourth part of the test are really tricky. I'm going to dive into them a little bit more here, and then I'll be done, and we'll see if there's some questions. So when you get to this question of would a product display ban advance a government interest? And there was evidence from Canada, other places have done this. But that evidence might not be conclusive because in Canada, the law not only restricted the visibility of the products, but it also restricted advertising. So what if a New York law or New York City law or Haverstraw law had also banned advertising? Well, then that's another type of speech that might not, where it might not survive constitutional scrutiny. If it did not ban advertising and you just banned the visibility of the product, then how well would it work? The evidence, again, is not so clear. As far as restricting more speech than necessary, the industry is very quick to say other laws could be effective here without restricting speech. What if you were more effective at banning this, of enforcing a law that prohibited underage sales, for example? And there is still this problem of legal adult consumers want to see if the product is available, and tobacco industry not only wants to say like tobacco for sale, but they want their brand out there so that adults will see their brand. So again, it's not an easy challenge, or it's not an easy test to pass, giving these two factors where you need evidence that it works, but you also need to make a claim that you're not restricting more speech than necessary. So in summary, just to use a similar color pattern, I walked through a couple different types of restrictions. Sales restrictions all survived in the examples I used. Warning restrictions had a better chance of surviving, and speech restrictions are more difficult to pass. But in New York's case, 1399 DD, I think, that was crafted a little bit more carefully than things that had come out of Massachusetts years earlier, and the tobacco industry didn't even sue. So, speech restrictions aren't impossible, but they do have to be done carefully. So that's my last slide. Here's my email address for anyone who may have questions. I'm going to stop presenting and see what kind of questions we have. Thank you very much.
Thanks, Kevin. That was great. And we do have some questions. And Kevin, while you absorb those, maybe I'll just kick it off with the first question we got, which is whether we know of any jurisdictions that are facing commercial speech challenges currently, and if not in New York, elsewhere. And I will say, and Kevin, you can chime in if you're aware of anything. The only one that I know off the top of my head is the ongoing litigation over the FDA graphic warning laws. It's possible, I'm sure there could be cases. There's a lot of jurisdictions in which lawsuits can be brought, but this gives an opportunity to maybe emphasize one thing, which we've also covered in our Litigation 101 publication and webinar, which is that just because industry has not yet sued over a law doesn't mean that they won't or can't, and it doesn't mean that they won't win if they do bring a lawsuit. At the same time, in the flip side, just because somebody does sue over a law doesn't mean the law is unconstitutional or that you'll lose. So when you think about crafting laws or you think about laws that you have on the books, hopefully you're talking to your attorneys to the extent you have them and discussing your risk tolerance, because there's a lot of unknowns in litigation. And just because something's been on the books doesn't mean it will continue to successfully stay there. I don't know, Kevin, if you want to add anything to that.
Nope.
The next question I see here is, has there been any smoke warning signs similar to the SALT graphic elsewhere in the US? And again, I'm not sure off the top of my head whether there are any, but as Kevin referenced, there is also a preemption issue with warnings on cigarette products because of the FCLAA, the Federal Cigarette Labeling and Advertising Act. And so generally jurisdictions would run into more problems than just constitutional problems that they want to put warning labels on cigarettes. But the FCLAA doesn't apply to smokeless tobacco products, and to my knowledge, it doesn't apply to electronic cigarettes. So there's potential avenues to explore there. It's also with regards to health, and so possibly environmental warnings might be permissible, but that's an untested theory. Kevin, you probably have more experience here.
Yeah, I have some thoughts on this. I don't, not examples, but in New York City, we used the salt shaker in large part because we didn't have something like graphic images to use. I think it's a better idea to use a graphic image as has been done for cigarettes around the world. You know, there's 125 countries that have laws requiring these graphic warnings, and the US is late to the game there. Why use graphic warnings when you could use like a salt shaker? Because they're showing actual health consequences. And if you anticipate that you're going to be sued with the Zauderer standard, you want to show that you've got actual results here. This is factually accurate. It's uncontroversial. It's something that could be taken right out of a medical textbook as the consequence of a certain type of action. And when we were looking at the sodium issue, we were like, well, how do you come up with a visual that reflects enhanced risk of CVD? You know, you could use a heart or something like that, but it's a little bit more abstract, just when you're thinking about the medical risk. So we thought that a salt shaker was something that was pretty universally identifiable, and coupled with the text, it would help create a message that people could understand easily.
Yeah, and I think that illustrates the difficulty in crafting these sorts of laws in anticipation of potential challenges. My understanding of the FDA graphic warnings is that the illustrations really are, if not directly taken from medical textbooks, certainly could be, and that a lot of effort was put into crafting images that were medically accurate and not over the top. And they did that, and it still conveys a really big emotional punch because these are really horrific diseases, and so you don't need to go overboard to make your point. But as you think about crafting these sorts of laws, those are the considerations that you have to keep in mind, because if you do go too far, then you get into that territory where it isn't factual, where it's controversial, and you might fail that souter scrutiny.
Yep. And I see the next question is, who argues on the side of public health in these cases? And Tom can chime in on this one, but just from like a city side, New York City has its own law department. It's a big city, of course, and it has a bigger law department than a lot of other municipalities. But if it's a city law, there's typically going to be a city attorney up there arguing, and if it's a state law, there would be a state attorney arguing. But then there's also opportunities for other groups like the Public Health Law Center to submit amicus briefs or otherwise be engaged, and Tom can probably share some thoughts on that.
Yeah, and so if you are, employed at a smaller city or county, hopefully there is a city or county attorney, although they might have to wear many hats, and so possibly this sort of litigation is not in their core area of competency and experience. Sometimes in those situations, I understand jurisdictions will hire outside counsel to represent them, or find somebody who could do it on a pro bono basis. There's a lot of great public health law groups out there who might be able to take on that sort of direct representation. But PHLC, as we mentioned at the top of the hour, doesn't do direct legal representation, but we do often submit amicus briefs in support of parties who are defending these sorts of lawsuits. And an amicus brief is it's a friend of the court brief. It's an outside organization submitting a brief to the court, providing it with additional and useful information, usually in support of one of the litigants. So here it would be in support of the defending city or county or state. And that sort of thing, you hope educates the court and tips the scales a little bit in favor of the party that you support. The next question is, the writer says, admittedly a little off topic, but I think it's relevant, is how should governments best work in areas of unclear legal status like speech restrictions? And I think, probably you got the message through both Kevin and my presentations that the First Amendment realm is very complicated and unclear and difficult to predict. And so, typically the best advice is to talk to your attorney if you have an attorney, and they'll run you through the risks so that you can be aware of those before you really dive into the drafting process, and you kind of get a sense of where those guardrails might be and what your risk tolerance would be. But as we talked about, part of this is too kind of drafting strategically and conservatively, making sure that you're providing the factual findings, you're thinking ahead about the legal doctrines and texts and pitfalls that you might run into, and so that you can draft around those. And I know Kevin gave some great examples of how they did that, with explicit reference to some cases that came before. So if you want to add on, Kevin.
No, I don't have anything to add on that.
Okay. Let's see. And then the other questions I think are fairly specific, and hopefully maybe we can answer those off camera. And feel free to put something in the chat as well if anybody has a question.
Just on the last question, how does the FDA graphic warning signs affect these cases? So I guess that means after the Fifth Circuit case has been decided, how will that affect some of these other cases? First, if the Fifth Circuit case is upheld, or if the Supreme Court doesn't take it and that becomes the final decision, I think that's a good sign for other jurisdictions that are interested in passing similar required warnings. If the Supreme Court gets involved, we'll have to wait and see what they say.
Yes. Well, I think with that, we can wrap things up. I do want to note that we have a publication on commercial speech specific to New York State. I put that I'll put that in the chat here to everyone. You can also find it on our website. And I want to thank Kevin again for taking the time and blessing us with your expertise, experience, and knowledge here. It's always really great to hear these stories and hear you opine on them. So thanks for being here, and thanks to all of you for joining us today. Hope you found it informational, and please do reach out to us if you have further questions about these issues. We're always happy to provide legal technical assistance in this area. Thanks, everyone.